Welcome to Lawyers in the House with Motley. Wish you had a lawyer in the family? Now you do. Here's your host, Veronica Waters.
Welcome to the House, Lawyers in the House with Motley on WSB. Yes, you know that melodious voice. It's your girl, Veronica Waters, back in the house with you. So happy that you are in the house with me. When you are hurt through no fault of your own, you have one simple destination: wellness. You want to be made whole again, and you want your wholeness, such as it is, to be both physically and monetarily. You want to be made whole. You want to get as much money as possible. You want your life back on an even keel. You want to be well again. You want to feel good. You want to feel strong. You want to feel healthy. You want to know your medical bills are paid. You want to be at peace. You just want to go from A to B, from awful to better. But what if I told you that your journey from awful to better is not a straight line? It's going to take maybe a little zigging and zagging to get there. And oh, by the way, as you go from A to B, there are some missteps you could make, which could be explosive mistakes. You can cut that journey short with one simple misstep. Here today, we've got a Motley injury attorney in the house who is going to be able to navigate you safely through insurance company minefields. And welcome back to the house, Mr. Craig LaChance. So happy to have you sitting next to me in the chair today.
Thank you. Good to be here.
Yeah, well, you don't sound that enthusiastic, sir. What's up? One of our solo dolo. I think you're like, am I correct that are you in shock because I'm pronouncing your name correctly?
I am.
All right. So if you've been rocking with us since the beginning of Lawyers in the House, you remember one of our earlier episodes was with Craig, and I spent the entire hour calling him Craig LaChance, and he never corrected me. And I am such a lover of words and language that when I found out, I was so embarrassed. And guess how I found out? I said, hey, your name looks like it's French. Is it supposed to be LaChance? Does anybody in your family say LaChance? And he said, yeah, that's how I say it too. And I said, oh my gosh, why did you let me call you LaChance?
Well, I just go by Craig. I mean, I don't, no formalities here. All my clients just call me Craig. So the last name is superfluous. So we don't need to worry about that.
All right. Well, you're very kind. In the meantime, I'm the one who's on the worldwide interwebs calling you by the wrong last name. And your mom's mad at me now. Okay. So Craig LaChance, UGA undergrad, Georgia State Law. You're a native of Canada. And interestingly enough, you came to personal injury law after working for a couple of major insurance companies.
Yeah, that's right. In between my undergrad and making the decision to go to law school, I did work for a couple of major insurance companies for several years. And then in law school, I did a couple of internships. The law firms were interested in me because of my prior insurance work, and that just transitioned me into personal injury law, and I enjoy being on this side much more so than working for the insurance companies.
Why?
I just like helping people out and helping people get better and be financially compensated for their injuries versus trying to do the opposite, essentially.
Really? So I'm guessing that, some people have such horrible experiences with insurance companies. And it's like a former client was in here one time and he said it wasn't anything like he was familiar with growing up. It was like they were on the dark side or something all of a sudden, and not what he believed them to be. Does it feel like that as an attorney? You can tell me.
It does feel that way sometimes. I mean, I think it's a matter of perspective, but certainly from this side, we feel like we're doing the right thing. We're on the good side. And we're helping people as opposed to, working for insurance companies where you're sometimes standing in the way of people getting the medical care and the financial compensation they need to be made whole.
Yeah. Two businesses, both very good at what they do. But we're going to talk to you a little bit today about, as I said, navigating through insurance company minefields, how to maximize your wellness, both physically and financially. So, Craig, let's start off with, I guess, the obvious thing. You're dealing with insurance companies, right? Insurance is how people are made whole again. There are multi-levels, though, to maximizing that recovery. Where do you want to start?
Well, I think the most important thing for any personal injury client is to get into medical treatment right away. And we typically see clients, when I take that first phone call and inquiry about potential representation, typically one of two scenarios. Either they've gone to the emergency room, sometimes via ambulance on the date of the accident, and they have questions about where they need to go next, or they're calling us up maybe the day of the accident, a couple days later, and they have not yet had any medical care, but are having pain that they know needs to be addressed by a medical professional. And under either scenario, we'll talk to them about their injuries, what type of injuries they have, and give them suggestions and recommendations as to who might be best suited to provide care to them.
Now, is it too late for me to call if it's been a week ago, 2 weeks ago, 2 months ago?
There's going to be an outer limit as to how long you can wait to seek medical care, but that's going to be case dependent. So it's best they give us a call so we can give them an individual consultation about their particular case.
Okay. So you've got your medical care going, and I'm assuming that, do I need to, collect all of my copay bills for you, or how do you know what I'm getting done?
Well, if you hire us, if you hire a law firm to represent you, we take care of all that. We'll get all your medical records and bills directly from your providers. You just tell us where you've been, and we'll handle the rest for you. That's a big part of why you hire us.
Okay. Fair to say it's a mine I could step on if I'm not doing those couple things.
Absolutely. Quick example is a lot of people don't realize that if you go to the emergency room and have x-rays done in the emergency room, you're going to have a minimum of 3 bills. You'll have the hospital bill, which everyone assumes is coming, but you'll also have a bill from the ER physician that treated you, and they bill separately, and you'll have a bill from the ER radiologist who reviewed your x-rays, and they bill separately. And sometimes people don't take that into consideration, and maybe they settle a case quickly without involving an attorney on their own, and they think they have $2,000 in medical expenses, and they negotiate whatever settlement they negotiate, sign a release, and then 4-6 weeks later, you have additional bills showing up in the mail that you didn't even know existed. You go to the insurance company and ask them to pay it, and they'll say, no, it wasn't part of our agreement. So it's definitely a minefield.
Yeah, and it's having had medical coverage before, I know that those bills can kind of come drip, drip, drip. They don't all come at the same time either.
They don't come the day after the accident, that's for sure.
Yeah, okay. So I need to, how dangerous is it if I don't understand what my insurance coverage actually covers?
Absolutely. So, a lot of people, there's a big misconception. I'm sure we've talked about this on the show before about the idea of full coverage. In Georgia, there is no such thing. Coverages are purchased a la carte. So from your perspective, your personal insurance, you'd be looking to see if you have medical payments coverage that might cover medical bills, an uninsured motorist coverage that might cover you in the event the at-fault driver isn't insured or doesn't have enough insurance. And then on the property damage side, you'd be looking to see if you have collision coverage to repair your vehicle and rental car coverage to cover the cost of a rental while your vehicle is being repaired.
How do I get all that stuff?
Well, if you hire us, we'll take care of all that for you. But if you're trying to handle this on your own, you'll be looking at what's called your declarations page, which is a document that you should receive from your insurance company every 6 months that indicates the coverages that you've purchased and the limits associated with those particular coverages.
All right, so everything is on the declarations page.
Correct.
Make sure that, which goes back, everybody, to what we've been talking about how to make sure that you have what might be actually closer to quote unquote full coverage. I like how you said that. It's really a la carte.
It is.
You have to be very specific about what you're getting on your insurance.
And there's a lot of insurance companies now that market that, actually. I know you've seen some commercials from some of the major insurers that talk about only purchase what you need. Well, basically what they're implying is we're going to cut some coverages out that you don't think you need, but when the time comes, you'll be upset that, say, for example, you cut out rental car coverage to save a few bucks on your premiums. But when the time comes and you need to utilize it, you don't have that coverage. So just be careful. That's what that marketing ploy is basically we'll remove some coverages that you might have otherwise chosen to purchase to save you some money on your premiums and make us maybe more competitive with another insurance company. So you got to be really careful.
I never paid attention to that line. I know exactly who you're talking about, but as many years as I've seen those commercials, I never quote unquote heard that line until right now when you said it. Wow, that's incredible. So sometimes I'm going to be negotiating with the insurance company, right? Especially if my injuries are not so bad that I don't need to hire a lawyer, or it's not worth hiring a lawyer, correct? If my injuries are not super bad or the medical recovery it's not financially feasible. Am I saying that right?
Correct. Yeah, there may be a situation where you decide not to hire an attorney and attempt to negotiate a resolution on your own. And you'll see that in a couple of contexts. Of course, on the injury side, and I would always recommend that at least speak with an attorney first prior to trying to negotiate an injury claim. But if you don't accept the first offer. Do a little bit of back and forth. But you'll see it more oftentimes in the context of property damage, where an individual's car is a total loss. The insurance company does a valuation on the vehicle, and they send that over to you and say, this is what your car is worth. A lot of people will just accept that as gospel, where you may want to take some time, or I actually recommend you take some time and look at various resources online and confirm, in fact, that the insurance company is offering you a fair sum of money before you agree to accept.
Craig, we have heard time and time again that sometimes insurance companies will just offer you something right off the bat. I don't know if it was Ellis or somebody on the show one time, Ellis Liu was talking about having had a client called by the insurance company in the ambulance on the way to the hospital, saying, "Hey, let us send you some money."
Yeah, you see that all the time. And if we've got time for a quick story, I'll tell you a recent one. So I have a client who reached out to me after his neighbor said, "Hey, give Craig a call." His neighbor was a former client of mine. And it's a couple weeks after the accident. He had kind of worked his way through part of the property damage claim, and he had gone to the emergency room. And this insurance company said, "Well, hey, we'll pay you $1,000 and cover your medical bills." And they went ahead, and he was a younger guy, and they went ahead and he gave him his routing number and his check. And they put $1,000 in his bank account and then emailed him a release saying, just sign that release in exchange for the $1,000. Well, he sent me over the release. The release was unconscionable, in my opinion. Limited the medical care he could receive in both dollar amount and time. And we sent the money back to the insurance company and said, "No, thank you. We're going to move forward with him as our client."
Well, hold up. What's wrong with taking that $1,000? I know I'm gonna have medical bills. I probably have some right away. That's something that I need to do. What's wrong with me just taking the money?
Because it's only offered in exchange for a full release of claims, past, present, and future. So if you accept that money, spend that money, the argument is that you've agreed that that is proper compensation for your injury claim, and that you cannot come back to the well, as they say, a second time and ask for more money, regardless of how serious you're hurt or ultimately how much you end up incurring in medical expenses. So you got to be very careful at accepting offers early on in time. There's certainly no harm in waiting and seeing how you're feeling and revisiting that offer maybe a couple weeks later.
The first offer is a low ball.
Almost definitely. Starting point for negotiations.
Okay. It's one thing to say don't accept the first offer. It's another thing to say, hey, check your bank account. The insurance company might have slid something in there without you paying attention. Yeah.
I mean, again, typically speaking, in terms of how this works, the insurance company will not send the money until there is an agreed settlement with a release, and the release has been reviewed. So they're kind of putting the cart ahead of the horse in the hopes that you spend that money. And then once you spend that money, regardless of whether or not you executed the release, their argument is that, well, you've spent the money.
Wow. Had you ever seen that happen before?
I've heard of it. Yeah, absolutely.
Wow.
Yeah.
Just dropping the money in there.
Yeah. It's becoming more and more commonplace with digital banking these days.
That's crazy. Now, let's be sure as we get ready to go, take a little quick break here. This is not a quick process. What would you tell people about packing your patience for this journey?
Yeah, you've got to be patient throughout the process. Time is on the insurance company's side. They can take as long as they want to resolve the claim. They'll let it take years. For example, I had a case last week. I resolved at mediation for a client, and the accident was in 2019.
Wow!
And that's not even like there's most attorneys are going to have stories of cases way older than that, but that's just an example off the top of my head that accident from 2019, and we just resolved it in February of 24. Exactly.
5 years later. What to do if your lawyer is not representing you the right way? That's coming up next on Lawyers in the House with Montlick on WSB. All right, come on back into the house. It's Lawyers in the House with Montlick on WSB. I'm Veronica Waters, here with Montlick injury attorney Craig LaChance, taking a LaChance on him for this one-on-one show about insurance company minefields. Craig, I told folks going into the break that we can, if you are in an attorney-client relationship and you don't quite feel like that relationship is doing it for you, you can break up.
That's correct.
Let's talk about that a bit.
Okay. All right. So here's what I would look for with regard to an attorney-client relationship, at least in the initial few weeks, right? Number one, you want to make sure that you've at least spoken to your attorney. At Montlick & Associates, we pride ourselves on having an attorney provide the initial consultation to any new potential client. So I that to me is a red flag if you're not speaking to an attorney up front. As we discussed in the earlier segment, from there, it's important that your attorney make sure that you're in some sort of treatment plan with a medical professional that you're comfortable with. And your attorney should also make sure that your property damage claim is being handled, either as a total loss or repairs, whatever it may be, but that's being handled as well. From there, I think, another important check-in is going to be a little farther down the line with your attorney. And under Georgia law, the insurance companies have 60 days to provide you the available insurance coverages, both your insurance and the at-fault driver's insurance. So probably no later than the 60-day mark, preferably maybe even a little sooner, you'd want to have a conversation with your attorney about what coverages are available to me, what are the limits associated with those coverages, and how does that interact with my medical care and treatment and medical expenses to date, and more or less come up with some sort of game plan that's appropriate for the available insurance as well as your injuries.
So if I'm not hearing from my attorney very frequently, if I don't even know my attorney's name, if I don't know or at least have some kind of idea about what the game plan looks like, even if I don't understand most of it, red flag.
Absolutely.
And then what do I do?
Well, it's up to you and the individual person. If you're uncomfortable, you do have the right to seek out a replacement counsel if you prefer. I would recommend that if you're uncomfortable with your attorney, if you're getting vibes that just don't feel right, I would suggest doing it sooner than later. The deeper you get into a case and a claim with an attorney, the harder it may be to separate at that point. So if you're not getting the right feelings and vibes initially, I would consider making a few additional phone calls, presenting your situation to another attorney. We'd love for you to give us a call, 1-800-LAW-NEED or #WIN, and we'll talk to you about what the other attorney is doing. And I'll be honest with you, I take calls sometimes where I say to the potential client that, look, I think your current attorney's doing everything they can. I don't see any reason why you should switch attorneys. Alternatively, I'll take calls where I'm just flabbergasted, honestly, as to what the other person on the phone is telling me, and I'll say, look, I think I think it might be time for you to consider a switch.
And you can say, you are fired, lady or sir. I'm going to Montlick. I guess that's I guess that's how that conversation ends up. All right, coming up on Lawyers in the House with Montlick on WSB, we're going to talk about more of the insurance company minefield and where they're laying those mines. Stay with us. Welcome back to Lawyers in the House with Montlick on WSB. I'm Veronica Waters here with Montlick injury attorney Craig LaChance. We're talking about insurance company minefields. And if you missed any of those amazing nuggets that Craig dropped on our minefield today here on Lawyers in the House, make sure you get all of the best stuff once again when you subscribe to the Lawyers in the House podcast on your favorite podcast platform. And remember, you can always see our smiling faces as well on YouTube. Get voice and picture. It's amazing. Technology is so phenomenal. And you know what? We love to keep up with you all throughout the week. So why don't you follow us on social on every platform? We are at Montlick Law. You can reach me on social at Miss V Waters. Just FYI, a little nugget there. All right. So we're talking about insurance company minefields here on Lawyers in the House with Mr. Craig LaChance. And Craig, there are a lot of different places on that journey from awful to better, from A to B, where people can get tripped up.
Absolutely. And I think the starting point, and I know we've addressed this on prior episodes, but recorded statements is really an important thing to consider early on in the process. You want to avoid those at all costs. And if they are necessary, you want your attorney on the phone with you.
Well, but almost everything that I do, if I'm calling the cable company or something, they're saying this call may be recorded for quality assurance purposes.
Right, and that's a little different than a recorded statement. A recorded statement is where the adjuster expressly says to you, "I would like to do a recording with you regarding the facts of this loss," and it'll often be presented very early on in the process. Maybe not at the initial report of the claim, but when the adjuster who's assigned to your claim first calls you up and says, it looks like you were involved in an accident with one of our insureds. I'd like to talk to you about what happened. Would it be okay if I recorded our conversation? And most people, sure, I've got nothing to hide. I didn't do anything wrong. Absolutely. And that's where people go wrong because there are so many missteps that you can take in a recorded statement that you think you're doing nothing wrong, you're just telling the story. But I'll give you a prime example. Let's say speed is relevant to the claim. Someone turned left in front of you. A common defense from an insurance company is that, well, you contributed to the accident because you exceeded the posted speed limit. And you may, not even thinking about it, because frankly, you probably weren't sure how fast you were going. And you'll give them a speed that's later above the posted speed limit. Or you see you don't know, and then they'll ask some questions. A common thing that insurance adjusters do is bracketing. Well, they'll say, well, you don't know how fast you were going. Was it maybe between 40 and 50? And you'll say, oh, yeah, that sounds about right. Or if you say no to that, then they'll say between 50 and 60. They'll try to pin you down to a number that you don't need to pin yourself down to. And then they can later use that as evidence that you contributed to the cause of the accident because you admitted to traveling above the posted speed limit.
It's almost like the Miranda right of an insurance call, right? Anything you say can and will be used against you.
Exactly.
As we settle this claim.
And so our recommendation always is if you haven't already talked to us first, if a recorded statement is requested, my recommendation is to decline that and not necessarily you need to end the phone call, but to decline that and reach out to us.
Hey, Attorney Greg.
Call.
Yeah. Kind of like that. Hey, dude, This is what happened
because
today.
that's a red flag. Because as a general rule, if an insurance company has already talked to their insured and their insured has said, I've caused the accident, it was my fault, there really wouldn't be a need for a recorded statement. So a recorded statement is typically going to come into play, and a lot of people don't realize this, is in scenarios where they've already spoken with their insured and their insured is putting up a defense saying, well, I didn't cause the accident, or they were speeding, or they did this and they did that, and
I didn't do anything wrong.
And the other, our potential clients' actions contributed to the cause of the accident. So it's always a red flag when an insurance company asks for a recorded statement, because if they have already established liability, accepted liability on behalf of their insured, they're not likely going to be asking for that, at least initially.
So then let's say then one of these minds might be trying to put some of the liability on you.
Correct.
Yeah.
And so under Georgia, the law, that's called comparative negligence. So to succinctly put this, Georgia is a comparative negligence state. So what that means is, and in fact, we're actually modify comparative negligence if you want to get into the weeds. But what that means is you have to show, in order for me to recover from the at-fault driver, I have to show that the at-fault driver was more than 50% the cause of the accident. 50.0001, you can recover from the other driver. But it will reduce the amount of the recovery. So let's say, just for example, your case is worth $100,000, but the at-fault driver's insurance company says you contributed to the accident 25%, they would only owe you $75,000. They would take the full value of the case and then reduce it by the amount of comparative negligence that they're assessing on you.
That's legal?
It is, but we don't have to agree with their assessment. And this is a very common thing where we have cases where we feel that our client has zero responsibility and the insurance company tries to assess some percentage to basically hold down the award to our client.
Well, it didn't reduce my injuries.
Exactly,
so,
exactly. And sometimes those cases will require litigation to sort out. It'll require, deposing the defendant driver and getting their side of the story, putting them on record. I mean, a recorded statement, if you think about it, is really, it's unfair to our clients because it's giving the insurance company an opportunity to talk directly with our client and find out what our client has to say about the incident, almost like a pre-deposition. But the insurance company will never allow me to take a recorded statement or talk to their driver directly and find out what their driver has to say. Ooh. So it's kind of a one-way street, and it's just inherently unfair to our clients.
Yeah, don't go down that one-way street. Let's talk about blowing up your case. Let's go into the field of surveillance, Mr. Lachance.
Sure. So, in today's times, you're really going to see that mostly in terms of social media. Depending on what social media platforms you're on and how you have your privacy settings set, an adjuster may be able to go on and look at your photos on Instagram or see your posts on Facebook. Mm-hmm. And what they're looking for is evidence that you're not hurt as badly as you say you are. And I'll give you an example. I had a client who had a bad neck injury. He had to have a fusion surgery in his neck. And they found photographs after the surgery on his Facebook page of him riding around in a side-by-side, like a four-wheeler with the two seats.
Okay.
But the reality was he was going camping with his family, and they were just using it to get around the campground, go down to the lake, come back to the campground. He wasn't going off-roading on it, but they were trying to imply that he's out there off-roading on this side-by-side, when in reality, the explanation was much simpler. They were just cruising down, dirt roads from one place to another. He wasn't using it as intended as an off-road vehicle, but they made a big stink about that and tried to use that to hold down the value of his case. So our recommendation is, while your injury claim is pending, don't post any of this stuff. It can only ever be used against you. There's very little, if anything, that's going to be, seen in your favor. So,
if I might say, it does seem a little unfair. I mean, there's no telling. The road to recovery is not, to go back to what I said before, the road from awful to better is not a straight line. And some days there are going to be good ones and sometimes it'll be bad. And you don't know, maybe your painkillers were working well that day. Maybe it was a good day. Maybe you were smiling through the pain. It's hard to take a picture of one moment in time and say, well,
and it's not
clearly you're fine.
You're correct. It's absolutely not fair to our client to do that to them, but it's just a reality of the world we live in 2024. So consider adjusting your privacy settings, post minimal things. No photos of physical activities, water skiing, roller coaster riding, etc. If you're claiming that you've suffered a serious injury. And then you mentioned earlier, this comes up a lot. People will ask this. The context of actual surveillance, of hiring a private investigator, say, to follow you around, take photographs.
Does that happen?
It still does happen, but that is more in context of typically serious injuries, very serious injuries where surgeries are involved, and it's typically done in cases that are in suit, in litigation. It's not that common that you're going to be surveilled, in the early part of your claims process.
Well, a friend of mine had mentioned something about her accident. She had something happened. This company was at fault. And in her process of getting treated, she had to have a lot of treatment on her back especially. And so she talked about one time going to the doctor and saying, the doctor said, "Hey, you got any new pain?" And she said, "Yeah, I was outside the house. I bent over to pull up a weed that was in the flower garden." And the doctor notated that. And the next thing she knows, the insurance company is like, "Oh, well, she's out there pulling weeds, so that's why she's hurt. It's not because she fell off of this machine of ours or
Correct.
whatever."
Yeah. So you're talking about what we would call a subsequent intervening action. And basically what that means is a potential other source for your pain and injury other than the accident in question. So that could be a separate subsequent motor vehicle accident. That's probably most commonly how you see it. A client will have a motor vehicle accident in January. They'll still be treating for their injuries. And then in May, they get into another auto accident. And the insurance companies will try to argue that this subsequent accident is now the source of your pain and injury. And those cases, frankly, are complicated cases. You absolutely need proper legal representation on cases where you have prior subsequent intervening actions. But like you said, it can be something as innocuous as telling your physician that you were gardening and you bent over and you felt a twinge in your back. So you really have to, you obviously have to be upfront and honest and forthcoming with your medical care professionals. Otherwise, they can't treat you effectively. But just be careful as to what you tell them, because it will end up in your notes. The defendant insurance company, will get a copy of those records, and they'll see that, and they'll attempt to use that against you. So,
well, what about the fact that she was fine if she had to bend over and pull up a weed on the way to the car before she fell off this machine?
Right. It's you're in a weakened state now. So you're what we would call, oftentimes you've heard the concept of an eggshell plaintiff.
Let's talk about eggshell plaintiffs. What's up with these Humpty Dumpty folks?
Sure. It's really someone who has a prior health condition or prior injury that makes them more susceptible to future injury. And I'll give you a good example of that. I think I mentioned it earlier in this episode, but I have a client that had an auto accident back in 2019. Mm-hmm. Well, back in 2019, she was already on disability for low back. She had worked at a package carrier and had injured herself on the job and was on Social Security disability at the time of the accident. In fact, the photograph of the damage to her vehicle has her handicap license plate front and center. So that was an issue all along in this case. Well, she ultimately injured herself further and had to have a couple different surgeries. And as I mentioned earlier, we were able to resolve her case at mediation just last week. But that was a 4.5-year process. and it took a lot of time and perseverance and patience on the part of the client. We were ultimately able to get her a very nice award, but it took a lot of time. And if she had been impatient, we may have not gotten to where we ultimately ended up.
So 2 things jump out at me when you talk about this. One, how long that case took, right? 5 years is a long time. And the other thing is how your life just changes after an accident. Like I used to be able to weed. I used to be able to sit at the game and watch the Hawks play. I used to be able to climb stairs. I used to be able to pick up my grandchild. And now it's different since this accident. It's hard. I don't understand how somebody could argue against those very real things. Some injuries are, we've talked about how you can't see some injuries. Some of them are soft tissue. Some things are only revealed like through an MRI or whatever. But just because somebody's not bruised doesn't mean that their life isn't changing and hurting in a very real way.
Well, that's our pushback. When insurance adjuster or a lawyer hired by the defendant insurance company argues, you went on a vacation. We have these photographs of you doing this. We have photographs of you doing that. And the pushback is, my life didn't stop. I'm going to continue to live my life. I just now live my life in pain. And the idea that if you're injured that you have to stop living your life is just not, it's not necessary. You can continue to live your life. You're going to do it in pain. And you'll be able to tell a jury that if ultimately necessary.
It's your painful new normal.
Correct.
It's your painful new normal. Coming up on Lawyers in the House with Montlick, the Montlick closing argument is on the way. Stay tuned. Welcome back to Lawyers in the House with Montlick on WSB. I'm here with Montlick injury attorney, Monsieur Craig Lachance, talking to us about insurance company minefields, and you've been waiting for it this whole time. You know you have been, and the MCA is finally here. The Montlick closing argument. Craig, take it away.
Sure. So we just want potential listeners to understand that, all law firms are not the same. At Montlick Injury Attorneys, we pride ourselves again on providing a consultation to potential clients with an actual attorney, an attorney that's going to know the ins and outs of the law in Georgia and what the best courses of action to take might be on your case at that particular juncture.
So, Craig, really what I hear you saying is getting the right attorney is going to make a difference in how I get made whole again on the other side of that minefield.
Absolutely. Insurance companies perceive different law firms differently. Having a law firm that will take your case to the next level if necessary, like Montlick Injury Attorneys is always willing to do, to file a lawsuit in the event that the pre-suit offer is not fair to you, we're always happy to take that next step for our clients. And in fact, relish the opportunity to take that next step for our clients, because it's extremely important that we don't ever sell a client short. Because once an insurance company gets an inkling or an idea that the attorney that you hired isn't willing to fight for you, isn't willing to take the next steps, the appropriate steps to maximize the value on your case, they will lowball your client. And we simply can't stand for that.
So if somebody comes to you and says, hey, I'm Mr. Insurance Company, and I see your client with this photo of them in a dune buggy, and now I want to get all your client's social media posts ever since this accident happened.
Yeah. So that, going back to what we talked about earlier, in an ideal world, if you're involved in a motor vehicle accident or any other type of injury, we would really appreciate and hope that our clients would essentially go dark on social media, never discuss the accident, never discuss your injuries, and really try to avoid posting photos of any sort of activities that could be perceived as an activity that someone who hadn't suffered the injuries that you've suffered would be engaging in.
Yeah, not to be phony, but just don't give somebody ammunition. You just don't know.
Correct. Like you said, for example, a photograph of friends and family members sitting around a dinner table, that's fine. A photograph of you going off the diving board at your neighborhood pool, probably not good. So you just have to think about the context of the photo and how it could potentially be perceived.
It's great if you feel good enough to do it, but just keep in mind that somebody else is going to see that as ammunition to keep you from getting all the way back to better, financially and physically. Thank you so much to Monsieur Craig Lachance from Montlick Injury Attorneys. So happy to have you back in the house here on Lawyers in the House With WSB, I am Veronica Waters, and reminding you to be careful out there. If you're in one of these insurance company minefields, you never know when you're going to hit that tripwire. So consider getting the right attorney to help get you there. We'll see you next time.